Draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. You may be seated.
Good morning, everyone. Welcome to this session of the Second District Court of Appeal oral arguments. I'm happy to present Judges Kelly and Morris today. So we're looking forward to good cases. I think you all know the first case has been postponed, so we have 4 cases on the docket, and we will take them in the order reflected on the docket. We will take a break after the second case in about 10 minutes. So if you're here for cases 3 and 4, just be aware of that. Otherwise, we are ready to go with the first case, which is A&D Healthcare versus ACL Senior Advocates. And just a reminder, if you're the opponent and you wish to reserve up to 5 minutes for rebuttal, let me know. I'll be keeping track of time, and I'll let you know when we get to that point in the argument.
Thank you very much, Your Honor. I would like to reserve the 5 minutes for rebuttal.
Very good. You may proceed.
Good morning. May it please the court. I am Nicole Ramirez, here for appellant AMD Healthcare Solutions, the plaintiff in the below action. We are here on a case that is involving misappropriation of trade secrets, not involving a non-compete agreement. And so what AMD sought in the lower court was a temporary injunction seeking the return of their trade secreted confidential information, seeking to return access to their email logins that were company email addresses, and to enjoin the defendants from using the trade secreted confidential information to solicit prior customers. This was only for a temporary injunction. A full trial is set in February of 2024, not a date certain, but that's on the case management order. So this hearing that occurred was only involving part of what AMD claims it has trade secrets of. It was limited to a discussion of what has been called the customer list. But the error occurred below in both the defendant and the judge, confusing issues and the factors that are needed to analyze a non-compete agreement versus just misappropriation of a trade secret.
Some of the issues that I had when I was reading through all of this is, first of all, I wondered about the confidentiality of this list because it seemed to be fairly widely disseminated in non-secure ways to people, your clients or other employees. I also didn't see any evidence to show that any customer was actually contacted on the list by the appellees. I mean, what it appeared to be is that appellees manage these patients while the employ of your client, and these patients elected to follow them to wherever they went. So I was concerned about that. A, the confidentiality, and B, whether or not there was really any effort to access this list and to, to try to pull these customers over as opposed to these patients coming on their own volition, because these are the people that were caring for them.
Yes, Your Honor. The list that is discussed at the hearing and that is attached as an exhibit to an email, that is not the confidential information, the entire trade secret that is being discussed at that hearing. That list is really a summary. If you look at the evidence, you can see it's a list of names. It does have some information, some notes. I think the date of birth might have been on there, but further in the transcript, and I think also conceded in perhaps in the initial brief, that list is not all that's being discussed. What's being discussed is the database on the CareCloud system. And then there was evidence of that had been accessed improperly and downloaded information from it. Totally unusual to how that person would have normally downloaded the information.
So it sounds like what you're saying, that your issue is that this information was improperly acquired. And you're not necessarily making the case that it was used to actually entice patients over.
Well, regarding whether it was used to entice patients or not, the hearing was limited, that's for sure. And there is additional evidence not in the record. However, for misappropriation of trade secret, and one of the things I was going to get to next was looking at the actual statute involved. It involves not only actively luring the customers away, but the threat of it. And so there was already a stipulation to so many customers that had changed over. Some might have been relatives.
But you're
some were-
seeking a temporary injunction. And it would seem to me that in seeking a temporary injunction, I guess what you're saying is all you need to show is potential harm. Is that what you're saying to me? Because it doesn't sound like there's any actual harm that's ever been proved so far.
Well-
In terms of the enticing of patients, I understand you say possession itself is the harm.
Sure.
Yeah.
Well, and there was also testimony and documents put in about the number of customers who had gone over to them. And whether or not they were directly, that's,
But your client did present any evidence that any customers said they were contacted and they therefore changed because they didn't solicit it.
it was not presented. And but the statute does say quite clearly that improper means, or that, let me find it here in the statute. Maybe it's from the case law, or I'm reading quickly to find it. It's not only the actual use, it's the threatened use, because it's almost like a discovery violation. Once the cat's out of the bag, it's hard to put back in. And that goes on to the other elements that have to be proven from a misappropriation of trade secret, or for the injunction itself, is that the irreparable harm that you show when it comes to a trade secret violation. Once it's already been used, it's really hard to get back. So the
So what evidence was there that it was used?
The electronic information was improperly downloaded, and many of the customers went to the other side. There is also case law, I believe it's the East case, or the Mapai case, I believe I can say that discusses that, especially in a trade secret misappropriation case. Circumstantial evidence is going to need to be used, because when this is happening, it is trying to be hidden. It's not going to be so obvious what happened. When the CEO came back from her leave, and one by one, the employees left, then the last one was there. It was only after the fact that it was discovered this corporation had been created, before they left. It was only after the fact that she looked at the electronic information, and that evidence was put in to show that that last employee was suddenly downloading information and accessing files that would not have been in her job to do. So that shows the threat of it, that it's going to be there. Also, it's circumstantial evidence, the testimony about.
That's that it could be used improperly, or that it is substantially likely to be used improperly, or actually is being used improperly.
Certainly okay, so you have the requirements for the trade secret statute, and then you have the injunction factors. So certainly for the injunction factors, it is substantial likelihood of success on the merits, that's for sure. So how do you determine whether we could have substantial likelihood of success on the merits? We argue that, okay, first we show that customer list does qualify as trade secret. And I'm calling it a customer list, but the testimony was that it was more than a customer list. It took years to develop. It included diagnosis codes, it included insurance information, it was not just a list of names of, people who might have illnesses that you could go get. It was not publicly available. So that, first of all, it was a trade secret, it possessed it. The next thing was that it was misappropriated. The misappropriation of the trade secret doesn't mean that they already have to have successfully running business to prove that they've used it. It took our person 5 years to get their business going. Oh, lo and behold, the employees who went off and started their own business, and we're not trying to keep them from competing, just from taking the trade secrets with them, were able to be up and running in 2 months. So those are circumstantial evidence that should support the finding. With regard to irreparable injury that cannot be remedied at law, the trade secret cases, and especially like that East case, which is the second DCA case, talks about how with a trade secret case, that loss of business and that loss of customer and the goodwill, the irreparable harm is presumed in that case. So in the trial court did not make that presumption. The trial court went out of their way to cite specifically the non-compete statute, the antitrust statute, chapter 542, which I'm calling the non-compete statute, to say I'm reserving on fees with regard to that. Well, in the non-compete statute, when you look right at it, the very first requirement is that if you're going to have a restrictive covenant, it's not effective unless it's in writing. Well, that's what the trial judge said, except where we're not moving under non-compete statute. This was an action under the trade secret appropriation statute, and nowhere there does it require a written confidentiality agreement. Besides that, we did show ways that we protected our confidential information. So, substantial likelihood of success on the merits. Is it a trade secret? Is it confidential information? We say we've shown that. Also, to be trade secret, it has to be reasonably protected. So you had to have a login. The whole CareCloud system is a system that is sold to medical professionals. There was testimony that it was an H17 level electronic system, and that provides extra protections from hackers and that sort of thing. You had to log in, you had to have a password. The only people that had passwords were employees. The appellants or the appellees seemed to want to argue that because all the employees had access, it wasn't protected. Well, it was, I don't know, 4 or 5 employees. It's not a, multinational corporation. It was protected from the public. That's what's important, not from each other. One of the other arguments that the defense wants to make is that there was some email where that list, which is a summary, that's not the whole confidential information we're talking about. We're talking about the database, but where that was given to someone who maybe possibly was no longer employed by them. Our CEO testified, yes, she was an employee. If it had gone on one occasion to one person who was previously employed, would that be enough to say it wasn't reasonably protected? There's certainly no case law that would support that kind of finding. So the injury outweighs the harm. This is not a non-compete. They're not going to be prohibited from doing this. We're simply asking for an order that requires them to not misappropriate trade secrets, to return the confidential information, to not use it to solicit others, and with relief that would serve the public interest. Also in the East case, it specifically says, as to the 4th prong, it's apparent that an injunction prohibiting a former employee from using trade secrets to solicit existing customers clearly does not disturb the public interest of protecting legitimate business interests. So this is not about keeping people from calling them. How could we enjoin that? This is about their actions for things that they knew. And the error occurred below because the court the whole time was looking at this testimony and thinking of it with an eye of the non-compete. The requirements for the non-compete are different. For the trade secret appropriation, misappropriation means acquisition of a trade secret by a person who knows has reason to know that the trade secret was acquired by improper means or disclosure or use of the trade secret. That's what the statute says. Misappropriation is both. It's not, it's not one, or it doesn't require both, I guess is what I'm trying to say. It can be one or the other. And at the time of the disclosure or the use, they knew or had reason to know what what they had was trade secreted. It was stipulated and conceded that they signed the confidentiality agreement. And there were other agreements that were put in, maybe not signed by those defendants, but that concession should be enough. So that's why also, with regard to one of the defendants who conceded signing the confidentiality agreement, first of all, the trade secret was protected even without that. That was just one other method.
Mr. Reader's just to let you know you're at your 5-minute rebuttal time.
Okay, but that's why it should apply to all, because the statute itself does impugn that knowledge if you obtain it from someone. And I don't want to read the statute, but it also says if you obtain that from someone, then you're also obligated to follow that. So I'll save my rebuttal time. Thank you.
Thank you, Mr. Puffer.
Thank you, Your Honor. May it please the court, in reviewing this case, Your Honors had the benefit of the transcript of what occurred in the lower court. And I'd like to limit it to what occurred in the lower court. Counsel just argued again about there was all these nebulous trade secrets that were protected by passwords to this program and that program. None of that was argued in the lower court. In fact, if you read the judge's ruling, he expressly stated that they, counsel, were limiting the trade secret issue to the client or the customer list. That list that was sent to all employees, 2022 by email, that was not password protected, that did not require any access. It was emailed out by email to about 25 people. And that was significant because, again, contrary to counsel's representation, injunction in this case, the court made two observations. Number one, there were no signed confidentiality agreements. And the only reason he made that observation is because, quite frankly, counsel spent about half of the time in their case in chief discussing the confidentiality agreement. But the other part of the court's ruling was that, and I quoted, and I apologize, the page I don't have, but he expressly said that the evidence in this record for this emergency hearing that the customer list was disclosed and not protected, as well absent of the confidentiality agreement, needs this court to make the findings on this emergency basis only, and not to step in and provide the extraordinary relief of enjoining the defendant from the conduct that the plaintiff outlines in the motion. The court expressly found that they did not properly protect this document that they claim was a trade secret.
So does it matter that only one of the employees signed a confidentiality agreement?
Absolutely not. And we acknowledge that one of the employees did, but it's not a question of this document to be a trade secret. In addition to be something that's prepared, the person who's protecting it also has to take reasonable precautions to protect the status of the trade
So the
secret.
confidentiality agreement doesn't matter because the information wasn't confidential.
Correct, and that was our position throughout. By sending it out as a blanket email with no protections, no password, no codes, that document received, lost any trade secret benefits it had.
Does it matter that there was no evidence to show that the list was accessed to get patients?
As a matter of fact, I think the fact is there was nothing like that, and that's important to know too. I appreciate it, Judge Morris. Counsel says we just want to return that list, but the fact of the matter is there was no evidence to suggest that my client ever used that list to solicit. In fact, to the contrary, the evidence was presented and even conceded by the appellants, employees, that they have no information to suggest that my clients attempted to solicit any form of patients from that list. In fact, these patients, and it is a healthcare business, my clients were the particular healthcare providers to these patients. The evidence what presented was the employer didn't provide these people with email addresses. The employer did not provide these employees with cell phones. So the patients had to have the healthcare provider's personal cell phone number and email address. And the testimony was presented that when no one from AMD responded to the patients who had my client emails contacted them. And then right here because AMD did not. And that's significant because contrary to what counsel is saying, here just for clarification, in the lawsuit, they not only say don't use the list, but they ask the court for order saying you cannot treat any of these patients. You cannot contact any of these patients' doctors or other healthcare providers. You can't communicate with any of them. Even if they contact you, you can't talk to them. And that was the injunctive relief sought in the original complaint. And that was the relief sought in the emergency motion for temporary injunction to prohibit my clients from treating patients who contacted them. We talk about harm to society. When patients can't go to healthcare providers that they choose, and there is no non-compete in this case, that is a great harm to society. And in fact, what counsel is trying to do is turn this confidentiality agreement or this alleged trade secret into a non-compete agreement by saying you can't treat the patients you personally treated while working for AMD, even though there is no non-compete agreement. Now, also, by the way, it's not just the question you address, obviously you're about capacity, and I'm probably, you all know this better than I do. It's not whether the trial judge may have been wrong. He said in his ruling, they didn't offer evidence to show how they protected this patient list. In fact, said he didn't. That's his ruling. You may disagree with that ruling, but that is not the basis for a reversal. You must find that the trial judge abused his discretion in reaching that finding. Clearly abused the discretion. And in the evidence presented, and it was just a 2-hour hearing, the judge didn't make an error in our opinion, but even if you believe he did, it's not the type of error that rises to the level of abusing his discretion based upon the evidence that was presented to him, based upon the testimony he heard and what he observed in trial, reviewed all the exhibits in trial. So going through that, and of course, looking at the injunctions, Your Honor, point out, and again, this is somewhat reaching to the choir. The standards to be applied first off is that it will suffer irreparable future harm unless an injunction is granted. Now, counsel makes a statement saying, well, we don't know what the damages will be. But yet count 2 of the complaint is for damages supposedly resulting from the loss of business with the customers decided to go from AMD to my client ACL. So damages are readily calculable. It's loss and diminishment of income, supposedly resulting from my client misappropriation of a trade secret, which we don't believe is a trade secret. Secondly, that has no adequate remedy of law, which of course damages are available. That has substantial likelihood of prevailing on the merits. And again, Your Honor, despite what counsel might say, the only issue tried before the court, the only trade secret that was presented at the emergency hearing was this alleged patient list, client list. And in fact, if you read over the court's ruling, again, the court congratulated and thanked plaintiff's counsel for narrowing the issue to strictly the client list. Everything else she's talking about was not addressed at the trial level. They raised this, they talked about it, but it was just the client list, the patient list that was addressed as a trade secret, that for which an injunction was sought at the emergency hearing. So going on beyond that, that goes beyond the scope of what was presented. to the trial court. And then the temporary injunction will serve the public interest. If AMD is just saying, don't use our list, return the list, that's what the injunction sought, that would be fine. But again, that's not what their pleadings said. Their pleadings asked for an injunction to prohibit AMD and its principals and employees from treating patients who had previously treated AMD, patients that they were responsible for, patients who had their cell phone numbers, who had their personal email addresses, who personally communicated with my clients. That's the injunction. So the harm to society is telling patients, you can't treat with who you want, even though there is no non-compete agreement in place. That would be another argument. That's the council probably pointed. There is no non-compete agreement here. So clearly, the trial judge did not abuse his discretion in denying AMD's request for temporary injunction. And again, I just want to briefly point out, and I'm sure it'll have to, but under the Florida's Uniform Trade Secret Act, it is not only important that the document is created to be a trade secret, which is it drives independent economic value, actual or potential, but not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from it, from its disclosure or use. That's part of it. I would concede customer list, patient list, client list can be considered a trade secret. But the statute has a second part. This is Florida Statute 688.002 subsection 4, and that is that whatever we think is a trade secret is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. Now, I think the opportunity to make a lot of arguments in trial court, I think come up with about 10 minutes in the 2 hour, 50 minutes, the 2 hour hearing. But one thing we made clear, and which the worship brother talked about before, was sending out a meeting to a current and former employee without any protection, not satisfy the second part of the statute. Therefore, when you put it out there, just to the general public, basically without any protections, that document loses its under Florida's Uniform Trade Secrets Act. And for that reason, Your Honor, it is our position that in denying AMD's request for a temporary injunction, emergency version temporary injunction, the trial court acted properly. But more importantly, it did not abuse his discretion in considering all the evidence and reaching the ruling he reached. And you know, I think I have a little more time. If there are no more questions, and I recall the 3 B's of speech giving. Be precise, be brief, be seated. I will be seated. Thank you. Thank you.
I have one question I want to start with.
Yeah.
There was testimony from the other side, specifically on the question of whether or not any patient was contacted, and the answer was no. Was that impeached at all?
It was not, Your Honor. After that witness, the judge stopped the hearing, and I,
Request to have more time to impeach.
unfortunately,
So, in light of that testimony, even if these are trade secret documents, the list is confidential, deserving protection in that way. It seems there are 2 problems. One is the court made a credibility determination that no patient was contacted through improper means using the list. And then the second seems to be the irreparable injury part. If the court seems satisfied that the elements were not established. So it seems that the argument that your client presented to the court was, okay, even accepting this testimony that they never contacted somebody, they might someday do that, so we should get an injunction. Can't the court conclude as a matter of law that that's not sufficient for a temporary emergency injunction?
certainly, we have a high burden for abuse.
So
of
it seems to
discretion.
me your argument is the judge just got it wrong and we should reverse, but when you have a witness who is unimpeached, who says, we didn't use the information in any way, we didn't contact anybody. And I understand your argument, well, they might have been able to use the information to provide better care for the patient because there's a history in the notes somewhere. But why wouldn't we simply affirm based on no abuse of discretion in light of the evidence that was presented in this limited hearing?
While that witness was not impeached, there was prior testimony from AMD that she heard on the line patients who were discontinued
That's a credibility.
service. It certainly could be for that. However, the error is not in coming to a different determination based on the facts. The error is in the statements that the court said, that yes, the court said that the plaintiff failed to meet several of the prongs, specifically the irreparable harm, the not contrary to public interest, and inadequate remedy at law. However, by the judge saying that, when he also said that we had to have a signed agreement and he was reserving based on the antitrust statute, that means that he was looking at those factors with an eye towards a little slightly different requirement. Because since the trade secret statute itself explicitly says it's can be the threat of use, I agree. I wish we would have had more evidence of the actual use just over that testimony. But even without it, it should still pass muster, not rethinking the way the prior judge looked at the facts, but based on these facts and looking at the right statute, it does pass as sufficient. If you looked at it as a non-compete, then of course it wouldn't. And even if initially, and I've been through all through the transcript, maybe the motion, maybe the complaint, maybe it starts out kind of saying, hey, you know, you can't talk to these people, or these people can't talk to you.
Motion is broad enough that
Sure.
you could have prevailed had the judge found the evidence supported that. I don't think
Sure.
it is as sweeping a motion.
And it doesn't, I'm sorry to interrupt. And it doesn't mean the court would go that far either. So, and I didn't want to run out of time. If you look at the East versus Aqua Gaming case, which is the DC case 2001, 805-7 932, it would be really hard to distinguish our set of facts from the facts in this case, where the court reverses and okay, the lower court went too far and said, yeah, you can't talk to those people. So the appellate court said, okay, yeah, you're right on that. You can't go that far. But on these facts, yes, they should have been enjoined from using the confidential information to solicit customers. So that's it. That's really I can't see any difference between this case and our current case. Here, there also was no proof of use in this case either. So,
You're not out of your time if you wish to conclude.
and then just one other point, there was, the defendant made the argument that the information was not protected, but one thing that hasn't even come up is among medical professionals, the whole HIPAA law, everybody is aware, the health insurance information protection for.
Is that argument made to the trial court?
Yes, this was an argument also made to the trial court, which didn't come up today, and I just wanted to throw that out there, that these are all medical professionals, that information was protected regardless. And I believe my time is up. Thank you.
Thank you very much. Thank you both. The next case is Walmart versus McCracken.